Welcome to Employment Law This Week. I'm George Whipple. Our top story, Me Too at work. Sexual misconduct in the C-suite leads to shareholder lawsuits. Last month on this program, you heard that sexual misconduct allegations would start impacting shareholder value and reputation. Well, now we've got a case study in Wynn Resorts. After the Wall Street Journal uncovered multiple sexual misconduct allegations against casino mogul Steve Wynn, the company's stock fell nearly 20%. Wynn resigned a week later, but the company's troubles were far from over. The first shareholder lawsuit was filed the day Wynn resigned, and to date, 3 suits by shareholders claim that Wynn and the board breached their fiduciary duties to the company and its shareholders. Bill Milani has more.
The lessons here are clear. Harm to a company's reputation and finances when misconduct is alleged by employees at any level can be damaging. When those allegations are made regarding senior leaders, regarding the face of the company, as with Steve Wynn, as with Harvey Weinstein, the allegations can bring down the company itself. It is crucial that senior leaders and even board members be trained as to how to react when they become aware of allegations of sexual harassment or other misconduct by other senior leaders. Legal departments, HR departments must have in place protocols as to how to respond when such claims are made. It can be difficult where a general counsel, a head of HR, is asked to investigate the face of the company or someone to whom he or she might report. It's important in those instances that they are prepared to retain an appropriate third party, an outside law firm, to conduct an investigation, to react quickly.
The NLRB is seeking amicus briefs on whether the misclassification of an employee as an independent contractor should be found to violate the National Labor Relations Act. Former NLRB General Counsel Richard Griffin argues that misclassification violates the NLRA because it impacts the rights that employees have under the Act, including the right to engage in concerted activities with coworkers, join a union, and engage in bargaining. To date, the board has not ruled on the question. Amicus briefs must be filed by April 16th. The EEOC has approved its strategic plan for fiscal years 2018 through 2022. The plan indicates the agency will continue its focus on investigating and litigating claims of systemic discrimination, while exercising its prosecutorial discretion responsibly. The plan also calls for increasing education and outreach and for improving the Commission's internal operations. The plan appears to be relatively routine, and reaction has been muted compared to the Obama EEOC's strategic plans. Now it's time for our tip of the week. Kate Bally from Thomson Reuters is here with some advice on avoiding family responsibilities discrimination, or FRD.
FRD claims have been on the rise. Comparing the decade beginning in the mid-1990s to the decade beginning in the mid-2000s, claims are up 256%. Also, state and local jurisdictions, such as Alaska and the District of Columbia, are increasingly recognizing family responsibilities as a protected category. So what are some things employers can do to avoid FRD? Supervisors should be trained about making assumptions about caregivers. They should avoid unconscious bias and understand that males can also be caregivers. Personnel policies should be put in place so as to not unduly penalize caregivers, and they should promote uniform application of those policies. HR should be trained to properly respond and promptly respond to FRD concerns. And employers should create a culture that supports caregivers and upholds the requirements of state and local law.
Thanks, Kate. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.